Today's video will tell you about key legal challenges associated with a multidisciplinary integrative healthcare practice that has an MD, medical doctor, and a DC or chiropractic doctor, and other practitioners like nurses, psychotherapists, behavioral health counselors, acupuncturists, naturopathic doctors, and other healthcare licensees. Hi, I'm Michael H. Cohen. I'm founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients navigate healthcare and FDA legal issues and launch or successfully scale their health and wellness product or service. Let's say you've got Jane, who's a chiropractor, and she wants to partner up with a licensed medical doctor in an integrated or integrative healthcare clinic. Jane specializes in joint injections, and the MD does pain management. The chiropractic care also encompasses rehab. Let's say there's an acupuncturist on board as well, maybe a nutritionist. To keep the consistent branding, the integrated healthcare clinic uses a trade name. The therapies again include stem cell injections and regenerative medicine, PI, personal injury rehab, and electrostim, and functional integrative medicine, botanicals, supplements, herbal medicine. The clinic also plans to sell a branded skincare line as well, so very ambitious project. Now, the chiropractor brings in all the patients and is the one responsible for the marketing, because the chiropractor, in our scenario, is very accomplished, good marketer, hosts these dinners with seminars that advance the benefits of these different therapies and the multidisciplinary approach. So the first question Jane asks when she comes to us is whether she can have her professional chiropractic corporation call the shots and be in charge. This would be a mistake. The law considers the MD at the top of the food chain. The MD can't really supervise the chiropractor, but the MD can supervise mid-levels such as registered nurses. And the chiropractor can't supervise the medical doctor, which is why the chiropractic professional corporation can't call the shots. I'm saying in the eyes of the regulators. So calling the shots, I'm talking about who's being seen as being in charge of the patient's overall medical care. And among other things, the chiropractor's scope of practice can't include medicine, and the arrangement shouldn't trigger medical board investigations. The medical board is warned about medical doctors leasing their licenses to others, particularly medical spas. And these multidisciplinary healthcare arrangements are particularly vulnerable. A better model, in my opinion, is to have the professional medical corporation at the top of the decision making, and with a medical doctor having at least 51% of the shares, and the chiropractor, acupuncturist, registered nurse, psychologist, others collectively can own up to 49%. In other words, they can have a minority interest together. Now, another important point we've made is about the use of the term medical director. In a blog post, we heavily discourage use of this term. It so happened that Jane not only wanted to have a medical director, but she also wanted this title for herself. This would raise regulatory risk because it would imply that, Jane, the chiropractor, is practicing medicine, directing medicine, and that the chiropractor or chiropractic corporation directs medical doctors or the professional medical corporation. Now, the third thing to pay attention to is how the healthcare providers might share equally in the MSO that handles the business, administrative, and marketing sides of the whole operation. Then, of course, there are corporate documents to draft, like shareholder agreements. Whenever the healthcare provider has shares in the company, with somebody else, whichever company we're talking about, you need a shareholders agreement. Now, one thing that Jane could do is get an early read from us on her business model by scheduling a legal strategy session with our legal team, because before getting all the documents drafted, she'd really want to work through some of the issues that I talked about above and the regulatory exposures, because they're significant. Thanks for watching. If you still have questions, you can read our blog. You can click on the link below, cohenhealthcarelaw.com/contact, and you can send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.